All right, so this is Martha Minow, still the dean here, and as people are going through and getting lunch, I'm just so delighted and excited to introduce Chris Kelly. So Chris is a graduate of the Harvard Law School, but that's not the most interesting thing about him. He also was the first lawyer and the first privacy officer for a little entity you might have heard of called Facebook. And that's one of the most interesting things about him. But even more interesting, to me, is his master's degree in political theory from Yale University. So Chris brings to the subjects of privacy and security the most hands-on, practical knowledge, as well as big think, big picture. His work has included really an amazing array of experiences. He did run for Attorney General in California. His public and political activism has been profound. He helped to organize and was the primary proponent of the most successful ballot initiative in California, Initiative 35, which modernized California's laws against human trafficking and sex slavery. So he's an expert in direct democracy. And he also has worked as a lawyer. And actually, his work as a lawyer launched his career, his private practice with Wilson Sonsini and with Baker and McKenzie. Antitrust, you've heard of that subject, and some other important legal avenues into the digital world and the world of technology. One more thing, he's an investor. So he actually is deeply involved in the Silicon Valley and beyond innovative development of new technologies and new businesses dealing with privacy, security, but also many other activities. Some of these things you know better than I do. Rent, Lever, Evergram, Streamweaver, Fetchit. You've heard of these things? Maybe you'll tell me what they are. Okay. So Chris is here right now serving as the Klinsky visiting professor from practice. We are just so thrilled that we're able to bring someone of his stature and experience to be here teaching and also giving this public address. So as we welcome him here, I can't help but give you a framed version of the poster. Here it is.
Thank you so much.
Thank you for being here.
Okay.
Great.
So I'll put this aside for now, and we can get started. I would normally wander, but I'm going to stick to the podium a little bit today because I think that this is an exploration for all of us. I do want to absolutely leave some time for questions, so I may shorten things a bit if I go on a little bit too long because I haven't timed things. But one of the things that I end up discussing in this piece is the practice of writing and thinking, and I put it in a comedic context. So it's been interesting to go through that process as well. It's been a while since I've written something on the longer side. In any discussion of privacy, it's always right to begin and end with Louis Brandeis. Credited with leading the clarifications of privacy's importance to people and how it might be reflected in the law, he's also properly recognized for strong views about the importance of openness and transparency. But in getting to the fairly high-minded concept of privacy, it's important to remember that one of the most important law journal articles in American legal history is in essence a lament about the press becoming too gossipy. As Brandeis put it in the famous 1896 Harvard Law Review article, The Right to Privacy, the press is overstepping in every direction the obvious bounds of propriety and of decency. Gossip is no longer the resource of the idle and the vicious, but has become a trade which is pursued with industry as well as effrontery. To satisfy a prurient taste, the details of sexual relations are spread broadcast in the columns of the daily papers. To occupy the indolent, column upon column is filled with idle gossip, which can only be procured by intrusion upon the domestic circle. The intensity and complexity of life attendant upon advancing civilization have rendered necessary some retreat from the world, and man, under the refining influence of culture, has become more sensitive to publicity, so that solitude and privacy have become more essential to the individual. But modern enterprise and invention have, through invasions upon his privacy, subjected him to mental pain and distress, far greater than could be inflicted by mere bodily injury. In his later book, Other People's Money, Brandeis captured the dedication we must have to openness and transparency in this famous formulation. Publicity is justly commended as a remedy for social and industrial diseases. Sunlight is said to be the best of disinfectants, electric light the most efficient policeman. We might call this the Brandeis Duality, establishing the right to privacy in American law while maintaining a deep understanding of the value of transparency. Or if we were uncharitable, we might call it the Brandeis inconsistency, or even more harshly, the Brandeis hypocrisy, grabbing conveniently at assertions around privacy when the indolent are seeking entertainment and gossip, and turning to high-minded observations about the values of publicity when some greater public purpose, as defined by elites, is in play. Some, most notably Neil Richards in his book Intellectual Privacy, have argued that we should see this as an evolution from the earlier views of a Brandeis, and perhaps of critical importance, a Warren, who was writing in reaction to the experiences of Warren's wife appearing in gossip columns, to the champion of free speech and controls on government surveillance that Brandeis was on the Supreme Court. He captures in this notion of intellectual privacy, the notion of intellectual privacy that we should be seeking to protect. Well, it's certainly true that there was an evolution in Brandeis's views, and as you will see, I think the notion of intellectual privacy is a description of what we're seeking to protect with the concept of privacy as a helpful heuristic. I would contend that Brandeis's initial formulation is actually incredibly useful in capturing the most important part of basic assertions about the invasion of privacy. They stem most often from individual personal reactions of embarrassment and the attempt to control or curate the public presentation of the self as it is presented to others. In an era where the tools of that curation change radically, and in particular where the rapid spread of means for producing and accessing information about people means that there is much more information and that it is increasingly tied to individuals, there will inevitably be clashes of expectations and reality. These clashes are best dealt with through extensive but realistic transparency and openness about data collection and use. I want to continue the exploration of this Brandeis duality by discussing three incidents that can be captured best as stories of the translation between a relatively unrecorded to a recorded world. I say relatively unrecorded because there have always been individual memories, reactions, notations, and in many cases news coverage about various happenings, local, national, and global. It's important to remember that these memories are all, in a sense, technologies. But the change comes in their power to provide information access. It's limited in a way that the rise of cell phone cameras, social media, and search are not. Assertions of a pre-lapsarian world where people didn't know anything about one another, as are often put forward by some lamenting a destruction of privacy, just don't fit the facts. There were these earlier technologies. They're just not as powerful as the ones that we have operating today. Much of the writing reflecting objections to the rise of the internet on privacy grounds actually stem from a perception of professional threats. It's been clear to me for some time, and I hope is increasingly clear to you, that much of the skeptical and often hostile traditional news media reaction to the rise of blogs, social medias, and celebrities mentored by internet attention is driven in large part by fear that the gatekeeper functions that they are proud of achieving have been rapidly lost. But the changes we want to focus on go much deeper than alterations in traditional media. They extend to how we as individuals can experience the world. Think of the ways in which things have already changed, where once the analog perception of someone on the street disappeared every second into the ether, a digital camera now captures it and at least theoretically makes it searchable. The many angles of people capturing live events with cell phones can provide the potential of an immersive experience, and with Meerkat, Periscope, and others, can even do it in real time and spread it through the social graph-mediated internet that is rapidly becoming more powerful than traditional television and radio. Furthermore, computer mediation changes everything in that it changes analog perception by humans to digital data, and that data is much more susceptible to analysis as computer processing grows. Like almost all technology, such data can be deployed for the benefit of individuals by giving them information they can use to improve their own lives, but it, of course, can also be improperly shared and used for manipulative purposes. Additionally, it's important to recognize that we've moved from an era where the internet is a relatively unidentified space to one that ties most activities to an individual identity, most commonly a Facebook profile. But this, of course, applies to personas operating on Twitter and Instagram and Tumblr, Google+, and many other potential competitors. Snapchat is out there too. It says it's ephemeral, and often it is. Len Kleinrock, one of the internet's founders, has often said that one of the mistakes they made in setting up the initial architecture of the internet was avoiding strong identity in login credentials. That choice made for the regular assumption that most online interaction was anonymous, what the New Yorker best captured in Peter Steiner's 1993 cartoon of dogs sitting in front of a computer, with one saying to the other as he surfed the net, "On the internet, nobody knows you're a dog." Bowing to reality, the New Yorker recently published an updated cartoon of two dogs sitting in front of a computer. One's lament to the other, "Remember when on the internet nobody knew who you were?" In talking about this transformation, the first of the stories I want to examine is one that has become the main refrain for those who want to criticize Facebook for insensitivity to privacy concerns: Facebook Beacon. There were, in fact, product design mistakes, especially around the transparency of how information was transmitted from third-party websites back to the Facebook newsfeed. There were even larger communications errors in introducing what was fundamentally a connectivity tool in conjunction with an advertising update during advertising week in New York City. The core of these errors were rapidly corrected by an expansion and increased reliance on the privacy infrastructure Facebook had already built, and Mark Zuckerberg issued an apology for the way it was handled in December of 2007. But the fundamental idea about allowing a person to share what they're doing on a third-party site back with their Facebook friends was a solid and meaningful one, and has since been extensively accepted by the Facebook user base and by the internet as a whole. Even though most report accurately that the Beacon program was discontinued, the principle that it aimed to reflect of connecting web activity back to the social graph was continued in Facebook Connect and the login system that allows for easily establishment of accounts on new sites. It has been copied by Google with Google Plus logins tied to Gmail accounts and Twitter, Tumblr, and a number of others. Before Facebook Connect and all these other login programs, there had been attempts through a variety of standards bodies to foster different sites talking to each other and sharing information because fundamentally people were seeking a simpler online experience tied to their identity. This interaction is now a core part of how people experience their friends' updates, and willing sharing of information about their lives contributes to the ease of communication and understanding. With the shift of many of our lives to mobile devices that are our constant companions, these interconnections allow for simple sharing and the replacement of attention to traditional media with the seeking of the next status update, tweet, or Instagram video. Some of the mistakes in the Beacon situation occurred because the Facebook team had eventually smoothly navigated another controversy over perceptions of the move from a relatively unrecorded to a recorded world, around Newsfeed, our second story of transformation and adaptation. In the fall of 2006, we changed the way Facebook worked by replacing the need to navigate to someone's profile to see their latest updates with a gathering and presentation of that information that we called the Newsfeed. Importantly, the feed automatically gathered what your friends were doing and organized it for you. An algorithm was designed to present the most important stories first. This launch also had some communications problems. In fact, the announcement in the site interface, and the shift in the site interface was put up, and only one option was presented to users: clicking a button labeled "Awesome." Perhaps that wasn't the best communication strategy. Though some might argue persuasively, given the results, that people didn't yet know what they wanted. I'm not among those. I would have preferred a different communication strategy, but that was the one we had, and but it worked out okay. Ultimately, the fact that we had previously built privacy controls that limited the default sharing of information to friends and networks, and as I often pointed out, and will again here, that there was no setting on Facebook to allow sharing with the internet as a whole until 2009, carried the day. The user base stayed and became more devoted to the site as it grew. By delivering useful updates to people every day more efficiently, news feeds have become a core experience for many on the internet, and Facebook news feeds continue to lead the way with nearly 1 billion people looking to them every day. We're going to turn away from Facebook because I haven't been a part of what might be Facebook Story 3, the acquisition and rollout of the world of Oculus Rift and associated virtual reality technologies. And I managed to miss most of another controversy until I had to deal with it in the political realm, the late 2009 changes to site operations and the privacy policy after I left the company in August 2009 to run for Attorney General of California. But by making clear the objection to the changes, it turned out to be less of an issue for me, and the company addressed the issue by rolling back most of the changes and accepting an FTC consent decree in 2010. As my third story, I want to instead focus on something that's still in its early days: the rise of digital health and the rapid improvement of diagnostics in all areas. Fitbits, Jawbone Ups, Nike Fuel Bands, and soon the Apple Watch all offer real-time personal monitoring of physical activity, vital signs, and in many cases can use analysis of that data to highlight both your progress over time and perhaps prediscover health problems. Data can be used to save your life. It's done in hospitals every day. Now it can be done every day on your wrist. Some will undoubtedly resist heading toward these technologies on privacy grounds, while others will plow full speed ahead. I mean, how many of you use Fitbits or Jawbone Ups or right now? It's becoming more and more common. How many of you plan to get Apple Watches? So as was true in the Beacon and Newsfeed conversations, there will be objections to the very ideas of these technologies based on the possibilities of the new data being misused. Transparency on the part of the companies and dialogue about exactly the way that data flows will go far in allowing this transformative technology to move forward. Apple's recent efforts in articulating its views on privacy by CEO Tim Cook and others are moving the ball forward in these areas. The presence of strong existing laws are also helpful here. Each of these must be put to a privacy test, and the presence of a strong consent-based law in these areas through the Health Insurance Portability and Accountability Act, HIPAA, makes some of the work that these companies must do obvious. While some will be obsessed with the downside risks, many more will focus on the promise of significant improvement of human health. Ultimately, I believe the key to unpacking worries about privacy so that we can embrace the benefits of technology is the identification of the core values we're seeking to protect. How should we protect the development of one's thoughts and opinions, and how do we turn the massive data that can now be created passively in the health area and is created actively by users of Facebook and Twitter and Instagram and all these other sites every day, while still encouraging expression and the creation of a space to try things out? How do we get the benefits of the transparency and openness of the Brandeis Duality while properly respecting and hearing the real human reaction to changes in technology that drove Brandeis's initial desire to set up enforceable privacy torts? Commentary comes from interesting places on this change from an unrecorded to a recorded world. Chris Rock, in an interview, recently lamented the problems of stand-up comics when they're used to being able to test out various threads before weaving them together in the acts that become famous. Now, the rise of cell phone cameras and that old bugaboo, the internet, means that the routine in the small comedy club can be quickly broadcast to the world before it's refined. In discussing the practice, he observed that you can't think the thoughts that you want to think if you think you're being watched. Thoughtful technology journalist Jesse Hempel captures the discomfort people sometimes feel around even permissioned observation in a brand new piece for Wired magazine called How I Learned to Quit Worrying and Love My Facebook Friends. She writes about encountering Facebook friends on the street who are really mere acquaintances, though she knows lots of details about their lives because she's been liking their pictures. What I'm describing is the digital equivalent of looking into your windows on a dark night, she says. You're the one who left the curtains open. You live on a busy street. But if we happen to make eye contact while I'm watching you serve mac and cheese to the kids, we both feel slightly violated. I do think there's a point here, one that both Rock and Hempel, I think, would concede are addressed largely by consent. But we should also point out its limits. Ultimately, Chris Rock's plan is to present some version of the comedy routine to the crowd and to have to engage on it. Facebook posts are willing actions. There is and there must be accountability. Rock's complaint is that the accountability of the presentation of going before the public comes too early and too publicly for his taste. And Hempel is ultimately comfortable with the situation that Facebook has helped create, in large part because both she and the subject helped create that situation. Consent matters here. I think it's also critically important to think about the time-shifting element that occurs in these situations. The presentation too early is one of the things that people are having less control over time. All of these things are first presented, drive reactions, and then there's a retrenchment and rethinking. This is actually a fundamentally human process of testing boundaries and then settling on a path forward. It's done in dialogue with people, with others. We also must think about setting rules and some individual controls around that protective process. And that's exactly what I think primarily animates both Chris Rock's and Jesse Hempel's concerns. The rules that are set don't have to be legal ones or just legal ones. Technology that respects and guides human choice around collection and use of data can often, and perhaps usually, be more effective and meaningful than the outcome of a legislative or a judicial process. I want to end the prepared remarks and open things up for questions with a return to Brandeis's original language and the important discussion in the review piece about idle gossip, which can only be procured by intrusion on the domestic circle. Paying special attention to this idea of the domestic circle, core personhood, and context may provide us with the best path forward in addressing legitimate worries about privacy. But we also must rethink the slightly overwrought assertion Brandeis makes that remains the starting points of many public claims about privacy invasion today. That modern enterprise and invention have, through invasions on privacy, subjected people to mental pain and distress far greater than could be inflicted by mere bodily injury. Modern inventions do challenge some existing expectations, and a lack of knowledge and changes in the public and private state of information may cause serious mental pain and distress, as Monica Lewinsky in her recent talk at the TED conference outlined quite compellingly. So I certainly commend that to your attention. But technology also provides ways to reimagine our humanity and to more effectively address our social problems, to engage in dialogue in space. They allow for the transparency side of our Brandeis duality and provide for that disinfecting character of sunlight and openness. We must be open about the transformations that technology is driving, and most importantly, companies must put transparency and meaningful choices around data usage at the forefront of design of new technology. Having and operating on a core privacy architecture that enables choices about what to share with whom were a major factor in Facebook's success and continue to underlie its staying power today. We're still at the beginning stages of a technological revolution that transforms the way that we communicate, the way that we understand physical space, and the way that we think about and share our common human experience. I've had the good fortune to take part in some of these transformations and hope that outlining a few of the stories thus far helps our understanding of the path we face going forward. We must remember that we are early in this transformation and leave ample space for innovation, even as we reflect on the common values and appropriate human concerns that led to the creation of the right of privacy and law in the first place. With that, I want to make this a very informative dialogue.
You led the Facebook campaign against sexual predators. What are the lessons from that experience, and how does that translate to some of the current concerns that people have?
So a lot of that is ultimately about data and identification. And there was there were a series of discussions that are ongoing in a variety of states about how effective sex offender registries are and can be. And part of our strategy was to make those registries more effective. That has had varying degrees of success. The overall move from a situation where there were literally sort of dozens and hundreds of sexual assaults going on online, driven by connections from social media and others, to our situation, which was there were tens of cases, which is going to be inevitable once you have hit a certain threshold of people. That crime comes online. That's just an inevitable thing. In accountability culture, though, when you've tied things back to identity, when you're enforcing a real name culture, makes a huge difference in the way that those things operate. And that's informed a lot of my other work, including on the Prop 35 situation, where we had to improve our state laws markedly. And we've gotten into a continuing dispute about some of the data elements, but we'll get that resolved eventually.
So Newsfeed caught a lot of people unaware because it, to use the term, surfaced updates they might not have thought everyone could see. You mentioned pushing more things public in 2009 for the first time. the sort of last shoe to drop in Facebook might be search, right? The social graph search popped up, but you still can't really effectively search for something, anything someone has said. Once that goes in, what will that do to people's expectations of privacy by obscurity? Particularly once you attach location to it.
And I think that there is a huge change that's going on in terms of that privacy by obscurity is becoming much harder of a question, and those expectations, are going to change. We're going to end up with more and more kind of computer-mediated data that's easily searchable, tied to the social graph. I think that the only strategy that the company has at this point, and I've been out of the company for 5 years now, is openness and transparency. It's just the presentation of ideas about this, the solicitation of input from various stakeholders, and in some cases there's going to be a conflict with what the company is trying to do and what certain stakeholders, their view of privacy, and that the people who are absolutely opposed to any data collection, who persist in a number of privacy-oriented advocacy groups, aren't ever going to be satisfied. And I think that the company should be very open about saying that, and we were when I was there. But that doesn't mean that we shouldn't listen to them. That doesn't mean that we shouldn't engage in the dialogue and try to explain the various things that go on. I've continued to be very friendly with a number of the folks who were some of our most prominent critics, and I think that they certainly have a voice, and they should have a voice in the process. That doesn't mean it's a controlling voice, and that doesn't mean that they necessarily speak for what privacy should be.
There's a mic over here. Can you?
Okay, sure. First of all, thank you for coming. How does Facebook, or how did, to the extent you can share, how does Facebook deal with foreign data requests by governments, especially related to, say, private messaging between parties?
So it depends on the country and on the perception. And again, having been out for 5 years, my commentary is much more about what was done when I was there as opposed to what's necessarily done today. So I don't have deep insight into the precise practices today. But there was always a concern about the misuse of data requests for political purposes in other countries, and it was a top of mind concern, particularly as we started expanding in the Middle East and in other countries. So what I'd say is that they were evaluated on a case-by-case basis with a strong bias toward following the letter of the law when we thought that it was actually decently protective of individual interests in those countries, and where we thought that the law was non-existent or sort of a sham, and there was a skepticism about the motivation of the inquiry, there was often active resistance and a comfort with pushing back on that, as well as on U.S. government data requests. I mean, you may have seen the company continue to push back on some of the subpoenas that have been issued in New York State and in some other areas, that there are laws around this that are generally okay. There may be some tweaks that the company would prefer at the margins. There may be some tweaks that activism groups would prefer at the margins. But in this country, at least, our data access rules are fairly respectful of people's desire to maintain their communications to fall private.
Thank you for your talk. It was great. So you mentioned the tension between the benefits and the privacy concerns of openness, but I feel like conspicuously absent was discussion of the tension between the public benefits of openness versus the purely pursuing openness as a way of selling advertisements, basically. And I was hoping you could talk about that.
I think that's a fair question and an important part of the conversation. I wanted to focus a bit more extensively on what I still see are the bigger issues, but I will highlight what I think Facebook has done terribly responsibly in this area, which is that the choice that we made at the very beginning, and it was an open discussion about it. It put us in a situation that largely caused the consent decree in 2010, where the promise was not to change things in a way that was revelation of actual personal data. The advertising on Facebook to this day works on targeting only in anonymous space, that there's only demographic targeting, geographic targeting. You can't buy a list of who on Facebook has declared their interest for a topic. You can buy an ad that targets people who have expressed that. You can target the 300,000 people who have expressed their interest in sailing. You can do that in a geographic boundary, but you cannot buy a list of those people. And that's, I think, an important distinction. It's one that doesn't fly with everyone. Folks who really would prefer that less personal data, anything tied to them personally online, is unacceptable. That's not going to fly with them, and that's, I think, again, openness and transparency on that is a very important way to approach this. With most people, that seems to work, and they seem to be fairly comfortable with that. It's important that the company continue to keep its promises on that, and to my knowledge, it has. That's part of this mediation and this change between the unrecorded to the recorded world, where normally people wouldn't necessarily know that you had these interests. Now you have a history of expressing them to your friends through Facebook, Instagram, Twitter, whatever. In other platforms, you've done that in a space where they say that there are no privacy settings, like Twitter, for instance. You put something up in a tweet, but it's fair game for advertising, for targeting, for, it's harder to gather now these days, but they do have the fire hose of data where you can basically get access to all tweets for some folks who pay enough money. We set a policy up that I thought was defensible and meaningful about the protection of privacy, and the company seems to continue to adhere to it to this day.
You're talking a lot about consent, and that being one of the bases of why you have privacy, how privacy should work. When you have people that either don't read a privacy policy well, don't understand the privacy policy, even when you write it in plain English, simply with graphics and beautiful, they don't understand it. And then act in ways that indicate they don't understand it, or even more, does things, and then the actions themselves don't seem to reveal anything, but the actions on aggregate reveal something different. So the classic example would be like the Target thing where someone browsed and they decided that she was probably pregnant and sent her stuff to her house. Or the thing on Facebook where if you have friends that are gay, we can infer that you're gay. Question is, so if you're basing it all on consent, how do you conceptualize people getting information where they really haven't consented, even though formally they have, but personally or morally they haven't?
Well, I think that this is one of those challenges that's been faced in contract law over the years and in any transactional law, where you've got a long set of terms and conditions, and that doesn't mean that somebody who's purchasing let's say fast food with a credit card, that they shouldn't be able to purchase fast food necessarily. You have to have an aggressive presentation of what's going on the platform, and certainly aggressive availability of insight into how data is collected and what might happen as a result of that. And I do think that a lot of the focus on hey, we're in this world where data is moving from this unidentifiable to an identifiable level is helpful in people coming to understand that. Again, this is a process over time. I do think that there should be actions based in concerns about privacy on companies who are trying to hide the ball, companies that are spending all their time trying to prevent people from finding out what's going on. This has been a fight in the industry for quite some time. That there were, I got involved in this 20 years ago, and people were like, well, people are too stupid to understand this, and a number of us said, no, we're going to explain this to them over time. And while I may disagree with some of the policy outcomes that somebody like Julie Angwin, who wrote an extensive series for the Wall Street Journal, put together, some of the things that she would want to hide more, I'm not sure it's necessarily appropriate to, or protect in law. The fact that series was done was something that I welcomed, and quite a number of other privacy people in the industry welcomed aggressively, because if your goal is to make people understand that there are risks to any information sharing, anybody who's saying that can be helpful. The question is when you get into the, we should have either, a government action or some other technological design action that prevents something that can have possible benefits. I think pointing out the benefits is a completely fair response to that.
Hi, thank you for your talk. You mentioned that some of these norms probably aren't best articulated through laws or formal regulations. I was wondering if you've seen in the industry any kind of consensus growing around appropriate privacy settings or norms in social media. You mentioned before the difference between Twitter and Facebook. I was wondering.
There have been a bunch of different attempts at that. And I think in part because people's ideas are still kind of fractured about the way this is going to develop, it hasn't really gelled in a completely, everybody coming together way. That there have been different interests in, commercially driven and different beliefs about the ability to dominate platforms and things like that, and different evolutions over time. That once upon a time, there was a very heavy emphasis at Google on the fact that search was anonymous or effectively anonymous. And then everybody's data was jammed together under a new privacy policy, and they're still facing some actions on that. Largely because it's driven by the threat of Facebook and worry that Facebook actually has better data than they do. At Twitter from the beginning, and Alex McGilvery, who's also a graduate of this law school and a fantastic guy, and who I was happy to help recruit at Wilson Sonsini long ago, they made a move to essentially say from the beginning, like, this is just, we're going to resist government data requests, and we're going to resist like private sector data requests on identity and other information. But generally speaking, when you put something up on Twitter, like, it's just up. Like, you can't have it taken down. It's just there. And that's one way to deal with this too. So a lot of it is sort of different philosophical approaches to these things, and so that's why there hasn't been a coming together around that. From time to time, larger companies have decided that they're going to lobby for federal privacy legislation, in large part to preempt state privacy legislation, because they saw the rise of a number of different things, some of which I think are fantastic ideas, like data breach rules, and others of which had other challenges to them. A lot of the California stuff has been, I think, very positive, including especially the data breach bill, which I, full disclosure, I did help write. But it's a challenge to bring people with disparate corporate interests together on a lot of this stuff. And some people who have more pro-consumer views and others who have more anti-consumer views, and there are some of them in the industry, and I think it's important for some in the industry to say that too.
Thank you. I appreciate your emphasis on openness and transparency, but I'm wondering about your opinion on default settings and the role that opt-in versus opt-out regimes can play.
And this is a critically important question, and one that ends up being a design question, and design questions are really hard. I think philosophically, I come very much from an opt-in perspective and a drive better understanding, but I've seen enough in terms of the way that people behave online, in terms of the fact that they run away from too much complexity on a flow into a site, that it's a hard question about where you set defaults that are gates, and how you promote things. And again, I think to their credit, and this was not something that happened while I was there. Facebook has driven the privacy checkups occasionally and things like that. I think that's really important. That you might have defaults that are, and the 2009 and 2010 problems that they had were around switching defaults. If you once you've set a default, you shouldn't go less restrictive. And that that should be a kind of rock solid principle. But you can look at how defaults operate and think about how defaults operate, and also highlight for people the choices that they're making. Again, this is I think people look at these things as binary moments, and one of the things that I wanted to try to get out in the talk is that there's a dialogue that goes on over time when a relationship is established like that, that you can determine whether or not it continues to be respectful, and you can vote with your feet in some ways, and and increasingly people would argue that on Facebook it's become a de facto necessity. From a legal perspective, I'm certain that's not true right now. But from a practical perspective, certain people do recognize that. And does Facebook have special, general obligations? Yeah, I think it does, and I think that they continue to derive great corporate benefit from the fact that they are somewhat respectful of the way that all this data is collected. And I think that if Facebook actually did a lot of the stuff that people accuse it of, that there would be a lot fewer people using Facebook.
Oh, thank you. So the Brandeis dualism or duality you started with, he was saying that we shouldn't allow media to poke its nose into our private business, but there's a legitimate function for sunlight to be a disinfectant, for government to have appropriate access to information. As we all have smartphones in our pockets and GPSs in our cars, and we are in effect keeping tabs on ourselves and each other, does that duality break down as we become a surveillance society, as we become, in effect, each other's big brother?
And I think that's a significant part of this change in computer mediation and the capturing of the data. Once it's there, before it just wasn't there. I see you on the street. I either remember that I saw you on the street or I don't. If I don't, that's gone. If I know that there's a surveillance camera and I see you on the street, and then I think later, oh, well, did I really see her? I can go back to the surveillance camera if I have access to it. So then it turns into a question of access to that information over time. I do think that there is a more default openness that's driven by that. And people come to know that those cameras are there. People come to know that they are operating in an online environment where the data is recorded, that on some router someplace and some server someplace, that the fact that they clicked on this or that could be present. Setting rules around that becomes a critical part of that. And some of those are practical, some of those are set by companies about how they treat government access requests for data, and also litigation requests for data. One of the things that I learned when I started litigating was how how stunningly easily you can collect a lot of information through subpoenas and other things in the discovery process. It's just and those of you who have worked in litigation already, will know that, and that's one of the things that you're trying to do. You're trying to collect as much information as possible and go through and find the needle in the haystack that'll affect the case. There's just a lot more information out there now, and again, I think that's something everyone needs to know, and that begins to inform behavior. There are concerns about people operating differently under surveillance than they do otherwise, and again, I think it's important to be open about that. But it's not that we're going from this world where there wasn't any surveillance to one where there is, where it's truly ubiquitous, even though it's certainly more prevalent than it used to be. Dean Minow and I have talked about this as well, and a lot of people sort of say that, well, we've gone from this small town agrarian economy where everybody knew everybody's business because they were seeing each other every day and everybody's gossiping, to a relatively anonymous large urban existence, and everybody assumes that that's now the default, but that wasn't always the default. The default used to be this smaller town environment where everybody knew everybody's business. So how you can't, and I refer to this in the talk as a sort of prelapsarian world where nobody knows anything. That never existed, and I think it's important to recognize that too. So this is, if I had to summarize more than anything else, I think everybody needs a lot more information about what's going on than we often get, and I think that's the beginnings of how we figure out where we set legal rules, and then where we have people essentially demand technological options and work with companies and form companies too. one of the things that I've learned over the years from operating in Silicon Valley is that where there are perceived needs, including a ton of privacy companies that have been founded over the last 20, 30 years especially, most of which haven't worked because they haven't actually reflected what people are looking for. They're looking for ease and convenience in a lot of situations, and the perceived privacy companies have been all about making transactions difficult or protecting too much in many ways. That ultimately commerce, offering, sharing information, building relationships is about sharing information. So you have to have some sharing, but you have to rule around it, and that's one of the things that I think we have to focus on.
Okay. So it strikes me that this kind of conversation we're having is about privacy amongst people, and that feels like a kind of 3 or 4 years ago question that we've been focusing on, so I kind of want to push it further a little bit. Which is to say that I think the main concern that we should be talking about, arguably, is about how the data is being used and how that affects our autonomy as individuals rather than our privacy as individuals. So a lot of what we're kind of skirting around is the idea that there are ways in which our data is being judged and acting on our behalf in these kind of black box systems that we don't really have awareness about how they're being used. And so you're talking a little bit about saying like, okay, well, the advertising data is not used in this way, but there's all these tertiary ways that we're not really kind of addressing here.
So, I mean, again, that's been a present worry all throughout this process. That, I mean, for years, insurance companies, everyone else has been gathering data that they've used through actuarial tables and often in individualized situations to make those types of judgments. So I think it's not right to say that that's somehow a new challenge or problem. Obviously, the scope of data and the type of data that's being collected and operating is a significant change. And the processing power that's available to crunch those numbers, to approach this, is a change too. And that has to be dealt with, from my perspective, open information rules. If you look at the Fair Credit Reporting Act, if you look at the way that a lot of these different acts work, and also the fact that they're not really enforced that much, is a huge issue, and something I think ripe for active reform. That there are some default rules that exist out there and that operate out there that just nobody gets to because there's too much going on. And and unfortunately our political system is so kind of mired in mud throwing on one thing or another, on stuff that's off the beaten path, instead of thinking about people's everyday lives. And one of the exciting, I think, transformations that I've seen is the rise of the Consumer Financial Protection Bureau, the operating, thinking about these problems in a different way. So it's an existing problem more than anything else that's amplified by the operation of technology. So I don't want to hide from that in any way, shape, or form. I do think that the person-to-person question continues to be one that we're grappling with as we operate, and now the network's been built essentially. The social graph is built out in a way that's operating effectively from some people's perspective, and too effectively from some people's perspective. And that's a respectful, that's something that we should have, I think, respect for that perspective. But there's a sense in which, choices about connection in the world, technology has become a core part of that, of a mainstream experience, and establishing, folks who want to live off the grid. There are costs to that. I think that people can make those choices, but that doesn't mean that every system should be the one that. And we face this with Facebook all the time. Especially everyone said, "Oh, well, I want to be anonymous, or I want to use a pseudonym on Facebook. I want to do this left, right, and center." And we said, you can be anonymous on the internet in various platforms, but this is not a platform that we do that. This is a platform where people use their real names and where we build trust based on that, and that's the way we're going to operate it going forward, and as a private business we're going to make that choice. If you don't want to make that choice, we're okay with that. And that's, the companies continue to stick to that. It's made some, I think, very good alterations around, You know, we have a big discussion about the drag queens in San Francisco who go by, you know, their stage names. I think that those sort of exceptions are fine, where it's well proven out over time, where people are using things. But the basic idea, one of the major changes that Facebook drove on the internet was you can now establish trust more effectively because you actually know who you're dealing with almost all the time.
We've been talking a lot about consent methods. I was just curious to know your opinion about technological consent methods, browser-based consent, do not track signal, and how you think the default positions of those technologies should be interpreted.
Well, one of the pushbacks that I always gave on the do not track discussions is that in order to effectively do not track, you actually have to track people. So there's a sort of problematic coherence to it at the end of the day. So if you're going to do a tracking mechanism, you know, the companies have come with one set of ideas. Folks in browser companies have come with different ones. And it turned into a bunch of games on the part of some of the browser companies too, that Microsoft would use Internet Explorer in a particular way to advantage a Microsoft advertising platform. When I was part of a lot of these discussions for Excited Home and a number of other clients. And it just got to be sort of a mess, and you know, we were formally, you know, not in favor of a do not track policy because of that perceived incoherence at Facebook. And you know, and I continue to be very skeptical about it to this day, about how effective it's going to be at the end of the day. Well, I think the principle of analogizing do not call, it makes some sense, and giving people more control over that choice. And look, if people want to put blockers on and everything else, I do think that's their right. Everybody should have the right on their computer to control the packets that go in and out. You know, I'm fine with that. I get that. It's when it goes to a standards body and the articulation that has to be the default because somebody doesn't want, you know, it's not their preference to have an ad company have the ability to get to them. I think that's a different conversation.
I have a question kind of moving in the opposite direction of limiting privacy. So you spoke a bit about crime on Facebook. And I think with sexual predators, that's a place where people have been able to agree that Facebook taking action is a good thing.
Right.
But I'd be curious to hear what you think about terrorism and other criminal activities and how Facebook makes those decisions.
You know, I think a lot of it was taking cues from the government terrorist watch lists and things like that for most actions. There are obviously some very sensitive conversations that the companies had to have over the years about and huge challenges about, particularly when it's somewhat of a crowdsourced platform for some things that are going on. You know, the fights over the you know, whether or not a city is in Israel or Palestine, whether or not you know, all of these different conversations about you know, about how you make decisions on these very contentious and very political issues. A lot of it has focused on violence and advocacy of violence at the end of the day. And you know, again, having been out for 5 years now, I'm not up on the current policies. But that was a lot of our discussion and focus. You know, we made very controversial decisions, and you know, as I said publicly, a number of conversations. And when I started a great dialogue with Brian Cuban on this after he took after us on our blog, on his blog, for you know, being anti-Semitic. Our very heavily Jewish management team was being anti-Semitic because we would not take down a site that asserted that the Holocaust didn't happen. And we had made what we thought was a very principled decision, and we articulated it to him, and we invited Brian to come to Facebook and give a talk about it, and you know, and we established a great relationship. He's a good friend to this day. Moving from the Holocaust didn't happen to, you know, kill the Jews, hate speech, no question about it. We take it down, and that's a rule that we set from the beginning. But the false statement of a historical fact is something that we were going to let the marketplace of ideas take care of that. And you know, the instant that it moves to any sort of advocacy, any sort of violence, any sort of attack like that, we're on it. And we've made that choice, and we think that's a responsible choice. But we also think that having false statements of fact that have political context can be a helpful thing about revealing people and who they are. And we agreed to disagree at the end of the day, but we thought that was a principled decision. So all of these hard choices end up being, and the drag queen situation came up too on the real name policy, and it gets a lot of press attention, and most of the press attention isn't very accurate. It ends up being very sort of skewed in particular directions. But those were in some ways fun issues to deal with at the end of the day. And I think that the company got very good at coming to what I see as principled decisions. And I think that for the most part, that's the way that most in the public have seen it.
So your career has combined public and private, and what's also fascinating is how much in the private you're making decisions, contributing decisions that have huge public consequence. So I guess my question to you is, for people who are interested in having an influence, what do you advise? Public, private, what mix?
I have been pleasantly astounded by how many things that are public challenges and that I perceive as public policy issues that can be addressed in private companies. And the ability to get more things done faster in the private sector that have good social consequences. I think that the current sort of sclerotic state of our political system is a source of frustration for everyone. And the ability to move in the private sector and do things that are allowing people to express themselves better in the world is huge. And so I encourage everyone who's public spirited to look at the private sector as a set of options. I also think that there are some great things going on at the NGO levels and others. And I still maintain a pretty active presence in some nonprofit endeavors. But a number of my companies with public purpose, so Loyal 3, which is customer stock ownership plans, allow people to buy in, no fees to buy or sell, or we get the companies to pay for it. It makes more sense as a public, as a for-profit business. There's plenty of dollars flowing in that space, and you just are repurposing them from folks who are skimming fees off now. It's best operated as a for-profit business, not a nonprofit. And there are a lot of things where the profit motive and sustainability of a company actually drives better behavior than you might in a nonprofit or a public space. So I think that people should be open to different models for how they do pro-social activism.
I think we'll end our formal session. Everyone join me in thanking Chris Kelly.